Good evening, viewers, and welcome to Elombah Television tonight. As you are well aware, on the 17th of September 2020, President Muhammadu Buhari signed the Nigeria Police Bill 2020 into law. The act repeals the Police Act 2004 to provide for a more effective and well-organized police force, driven by the principles of transparency, accountability in its operations, and management of its resources. Among others, the Act establishes an appropriate funding framework for the police in line with what is obtainable in other federal government key institutions. Since the signing of the bill, however, there have been several controversies with regards the effect on this bill on the powers of the police to prosecute crimes. Not just the police, the powers of other federal law enforcement agencies to prosecute crimes in Nigeria. Lawyers have debated the issue, and so tonight we have eminent lawyers in our midst to discuss this topic, tonight being the new Nigeria Police Act 2020, its effect on criminal prosecution. With us tonight is Mr. Isaac Oba, Principal Partner, Oba Isaac & Co., Editor-in-Chief, Erudite Judgments of the Supreme Court. Mr. Isaac, you are welcome to the program.
Thank you very much, sir.
Also with us tonight is Mr. Emmanuel Ewere Esquire. He's an international business law expert of ADVOCARE Lawyers, Abuja. Mr. Ewere, you are welcome to the program.
Thank you very much, Mr. Daniel. Always a pleasure to be here.
We also have Mr. Obunike Ohebu Esquire. He's the managing partner, Senfil Associates, Abuja, Federal Capital Territory, Nigeria. Mr. Ohebu, you are welcome to the program.
Well, thank you for having me.
Last but by no means the least is Mr. Sylvester Udemezu. He's a lecturer and legal practitioner at Nigeria Law School, Victoria Island, Lagos, Nigeria. Can we start with Mr. Ewere, please? What do you think about this new Nigeria Police Act 2020? What is your opinion on the law? Are you muted? Unmute yourself, please. Yes, go ahead.
Yes. Thank you very much, Mr. Daniel. I would like to say that there is less or no difference between the 1943 Act and the current one. Basically, they just aligned the act with the provisions of the ACJA. Nevertheless, they still retained the power of the lay policeman to prosecute. And this is more of a challenge to the Nigerian system because we already have a complex system where the office of the Attorney General is fused with that of the DPP. Now making the police have the investigative right and also the prosecution right. These are two collisions that will not give a system a fair balance. This will bring about conflict of interest. This will bring about distraction and also no justice, actually, I would say, low impact of justice. So I'll try to compare some of the 1943 provisions and also the current act that has been made out. In as much as the prosecution of criminal matters is vested in both the police, lawyers, and also the police and lawyers. Nevertheless, the Nigerian judicial system has suffered several inadequacies in the areas of prosecution. And I will focus my attention more on the conflict of interest of where a policeman finds it difficult to stand trial with a lawyer that has gone through the process of education and understanding how evidence and the procedures of criminal trials are being done, and a policeman that is trained to promote law and also enforce the law. Now, most of these lay policemen having the knowledge of arrest, investigation, and enforcement of the law come to courts and try to muzzle out an experienced lawyer that has gone through the rudiments of the practice. Actually, in 1943, when they brought in the lay policemen, this was due to the low. We had very few lawyers then, so this empowered policemen to actually handle prosecution, just like how in the Constitution it gave the president a qualification of the ordinary, in short, if a president can even read and write, you're qualified to be the president, not just the O level. So that was how the policeman was actually given the power to prosecute. Then we had few lawyers and even lay magistrates presided over criminal trials back then. But looking at our contemporary time, where we have a lot of lawyers, we have able hands and competent hands, I think that the current law is supposed to promote an efficient pattern, bringing in a law that will promote only lawyers, only those that have been trained in the act to prosecute. So the failure of this, because section 66, yes, section 66 of the Act that made provision for the powers to prosecute, just made reference to subject to section 174 and 122 that vested the power of the Attorney General to prosecute. Now, it actually gave the police to work based on the supervision and guidance of the Attorney General. Nevertheless, it did not restrict lay policemen from prosecuting. So I think we still have a challenge in the system. We still have more work to be ready to give substantial justice to our criminal justice system. So I think they have to go back to the drawing board and get something substantial. Thank you very much, Mr. Daniel.
Yes, we thank you very much, Mr. Ewere, for this introduction to this very, very important topic tonight.